So thank you very much to Caroline for setting up this event, to Vern for the generous words, and Jessica for that really interesting analysis of some of the implications of the advisory opinion that the International Court of Justice issued. I've got 3 points too, because it's fashionable tonight to have 3 points. And I thought what I'd do was focus in on, rather than take you through different pieces of the judgment, focus in on what I think the domestic implications are at a slightly more abstracted level. And so I thought I'd cover the nature of the problem, the nature of the climate change problem, and the way some of what the ICJ, the International Court of Justice, did shed some light on how that aligns with what you might call the judicial function, the role of the state and how that translates when you're moving from the international to the domestic plane, and then finally what I think of as, what I see as at least, normative tightening, which is I think what's going on as we progressively get closer and closer to points of no return, and also become increasingly sophisticated in how we measure how well or how badly, as Jess has just explained, we are in fact doing. So those are my 3 overarching points. On the nature of the problem, you hear a lot of talk, and you see this in judgments, you see this in criticism of judgments, about the scale and complexity of climate change, and that's sometimes referred to as a problem of polycentricity. And that phrase is used in the sense of trying to convey that we have an interconnected set of issues that affect multiple parties, and that interfering with those as a adjudicative decision maker may have repercussions that the adjudicative decision maker doesn't quite understand. In other words, it's a way of suggesting that adjudication or judicial intervention on those types of issues is inappropriate. And in my view, that is being used as a shield, and used wrongly, because polycentricity often is one way of describing a complex problem, but it doesn't actually explain whether there are legal questions for courts to address. So, for example, and I noticed Davey Salmon KC snuck in late here tonight, but he's here, who argued Smith and Fonterra for Mr. Smith. And I recall him saying in the Supreme Court that he'd had a robust exchange with the Court of Appeal. And I think it was on some of these issues around polycentricity, which the Court of Appeal was quite attracted to as a reason why the court was not well placed to grapple with climate change. What you see there is it being used as a shield in some ways, but actually polycentricity is something that we see in all types of judicial decision-making. Contract law is an area of law that judges are very comfortable in. Polycentricity abounds when you're talking about freedom to contract as you wish in a market environment, as does tort law, involves, again, polycentric issues. So it shouldn't, in my view, be used as a shield when actually there are legal questions that need to be answered. What you see the International Court of Justice do, and this is what I mean by setting an example, and I'll just refer to the final paragraph of the judgment, which is paragraph 456. I'm not going to read it to you, but I invite you to look at it, because what I think that paragraph does is it sets out the posture of the court towards precisely this issue. What the court says there are that the questions that the General Assembly presented to it are legal questions. It then goes on to say that as a court of law, it can do no more than address the questions put to it through and within the limits of the judicial function. And then it says that is this court's, the ICJ's, assigned role in the world legal order, international legal order. It then goes on to say that the questions also pose an existential problem of planetary proportions that imperils all forms of life and the very health of our planet. International law, whose authority has been invoked by the General Assembly, has an important but ultimately limited role in resolving this problem. What you see there is, I think, a useful way of looking at the polycentricity issue. That is recognizing that this is a complex, multifaceted issue, climate change. It recognizes that law will not be the solution to it, but it also very, very clearly asserts a role for law in answering legal questions as and when they arise. The reason I'm flagging this is because you can look at the Court of Appeal and Supreme Court decisions in the Smith and Fonterra litigation as very much reflecting those 2 different views. One, that there's a polycentric issue here where courts should not intervene, but then the Supreme Court unanimously saying that they thought there were legal issues here that could and should be determined by the courts. So you have a unanimous ICJ here endorsing a view of the judicial function that, in my view, aligns fairly closely with the way the Supreme Court approached it, which is recognizing that while there may be multifaceted complex problems, if there are legal questions that need to be answered, that is the role of the courts, and they shouldn't shirk from that. So that's the first point. The nature of the problem shouldn't be used to abrogate a role for the courts in resolving those bits of it that result in a legal question, which is not to say that it's simple, easy, or anything of that sort. The second point I want to make is about the nature and role of the state. And here, what you have to remember is that the advisory opinion identified in response to the first question the legal obligations of states. That was the first question. What are the obligations? So those are the obligations of states. The second question relates to legal consequences, but those are legal consequences for states. Why am I emphasizing states? Because the concept of the state in international law as a unitary thing, as New Zealand, is very different when you move domestically, where you start to get a much more fragmented reality. But what we can probably all agree on is that the legislature, the executive, and the judiciary, or those who exercise those authorities within a state structure, are part of the state. There will be more complex questions at the margins, and Caroline, I think, has offered you the opportunity to ask her questions about attribution and state responsibility, which may flush some of these points out. But the reason that's interesting to me is that it means that when you're dealing with what the obligations are and how they should translate domestically, it's not simply a question of saying, well, this is the court's role or this is Parliament's role. The state owes those obligations, and as you fragment domestically, you might see Parliament needing to step up. For example, if you look at the comment about the potential for the non-refoulement obligation that exists on states, the inability to return someone to danger, the idea that might be engaged by climate change and the adverse effects of climate change in a home state. That raises very real questions for the way the Immigration Act is framed, where you have recognition of the non-refoulement principle for refugees, and you have a protected persons regime that focuses on post-Zawi, torture, and arbitrary deprivation of life. Now, Parliament may need to look, in light of the advisory opinion, at whether it should legislate to clarify how that framework works, given what we now understand to be the international law position. Or, if Parliament does not, the obligation still exists on the state. Another part of the New Zealand state should step up and perform its function. The judiciary, for example, may need to exercise its interpretive role in interpreting the law compatibly with international law. So it's not as simple as one branch is responsible and one branch is not responsible for responding to what we now know in the light of the advisory opinion the obligations are. They are all responsible, and that will to some extent reflect the domestic legal order and how those branches interact with each other. But the reason I'm stressing this point is because there is a tendency to seek to marginalize the role of certain branches vis-a-vis other branches. That's not correct. The obligation lies in the state. If it's discharged by the executive or Parliament or the courts, then New Zealand has satisfied the obligation. If it is not discharged by Parliament, then we need the executive or the courts to do so. If it is not discharged by them, we will be in breach. And what the ICJ opinion does do, and shows you coming down the tracks very clearly in terms of next steps, is if you are in breach, you may very well find yourself in a courtroom sometime with someone like Justin arguing that you owe full reparation for your breach. And that might involve financial consequences. So people shouldn't underestimate how important it is for the courts to step up and acknowledge that they have a role here, regardless of what roles the executive and Parliament also may be playing, because they too are part of the state, and their conduct also will attach international responsibility. The third point, very quickly, that I wanted to stress is this idea of normative tightening, which I think we see happening, which what I mean by that is that as you see articulation of these standards internationally, that will filter through domestically. And I endorse what Jessica said about New Zealand having a dualist system, but what that means is you then have to go to the next step, which is international law is not automatically New Zealand law. But that doesn't mean that you say, therefore, it doesn't apply. It's a more complex question, which is where you have, let's say, a statutory regime. What you're looking at is the extent to which there is a relationship between international obligations and that particular statutory regime. For example, the International Court of Justice was very clear that human rights are implicated by climate change and vice versa. And they articulated, for example, the way in which Article 6 of the International Covenant on Civil and Political Rights, the right to life, plays a role in climate change. The reason that is significant from a domestic perspective, since we're talking about domestic implications, is that if you look at the New Zealand Bill of Rights Act, it has an analogue to Article 6 of the ICCPR in the form of Section 8 of the New Zealand Bill of Rights Act, which protects the right to life. The reason why we then understand the relationship to be an important one between those two rights, the New Zealand domestic one and the international ICCPR one, is that the purposes of the New Zealand Bill of Rights Act include, specifically in the long title, to affirm New Zealand's commitment to the International Covenant on Civil and Political Rights. So what I'm suggesting is that you can see from that when you're looking at what is the relationship between a human rights standard here, the right to life, internationally, whatever the scope of that may be, and we now know its scope to some extent in relation to climate change because of what the advisory opinion says, you know that there is a conscious and express legislative direction purpose statement saying that one of the things that the New Zealand Bill of Rights Act and the right to life there is trying to do is affirm our commitment to whatever it is the international right is. And so there you have an example of relationship where domestically you should expect to see courts applying the domestic right to life in a manner that aligns very closely with the scope of the international right. That obviously has implications for climate change. Another area where we see that relationship playing out is the Climate Change Response Act. It is surprising to me, at least, that so far there has been not much made of the purpose statement in that act that says that one of the things it seeks to do is one of its purposes is to ensure that New Zealand, again using the language of international law and the state, is able to meet its obligations under, among other things, the Paris Agreement. So again, if you're looking at the relationship, is this something that matters to New Zealand law? Yes, it does. Every single power discretion exercised under that act is going to be informed by its purpose of ensuring that New Zealand is able to meet its obligations under the Paris Agreement. So when you then go to the ICJ advisory opinion and you look at the interesting points that they make about the NDCs, which I won't go into because both Caroline and Jessica covered them nicely, those will filter through domestically through that purpose statement. So it might not be automatically New Zealand law, but you have a very clear legislative intent for courts to enforce that shows you that the relationship is intended to be such that what happens internationally necessarily impacts those domestic decisions. So for example, when you're setting your emissions budgets, it's not possible, given that purpose statement, in my view, to say this is a separate thing from the NDC. That creates an artificial split between the international and the domestic that the legislature has told us it does not wish us to pursue, because the legislature, Parliament, has said one of the things this act is meant to do is help New Zealand to meet its obligations under the Paris Agreement, as they've now been explained by the ICJ. So when I say normative tightening, what's happened is the ICJ has given clarification to what the scope of these norms is, and then when you can argue through that relationship domestically, you can access that reasoning as a way of explaining the way in which the domestic decision-making needs to play out. So tightening in the sense of the legal controls that exist domestically are increasingly becoming clearer and more stringent on the executive. And that's something that will get tested presumably through court cases as people find those areas where there are, let's say, for example, the transparency issues around how New Zealand plans to meet certain commitments. That might be one area where the international commitments mean that a court might be quite willing to step in, given the due diligence standard that it now understands to be relevant, and say, you need to at least allow this to be measurable, otherwise you're frustrating the purpose of the agreement. So that's just some of the ways in which I think you see normative tightening as those legal controls become stronger and more stringent over time.